All right, welcome to today's lecture where we will be discussing chapter number 6, legal issues in contracting. But before we get into that, I'd like to chat about the time, a couple of things. So the first of which that you can see available on Blackboard is the test timetable. It is the unstamped version. We wanted to get the dates to you guys as soon as possible. These are like 95%, 96% sure to be going ahead. So those dates are like very close to be accurate. I just can't give you the 100% confirmation because we don't have the stamp on it. So it's, yeah, the HOD has signed it off and it's gone further up to faculty. So it's like pretty much almost there. So take note, you will write CMT specifically. I only know my subject, so I don't know the others, but you can check there. They're all there. On the 22nd, the Friday, the 22nd of May. It's in the afternoon. And I did not choose this day. I'll tell you why I didn't choose this day. Because that's my birthday. And so if I had to choose a day, it would not have been that. But anyways, that's just a side note. Okay, so be prepared for that. We'll talk about specifics closer to the time in terms of what you need to know for your assessment or your FISA. And there will be a revision class specifically aimed at getting you guys prepared for that. Second to that is also marks I've uploaded on SOS or OPA, whichever platform you prefer to call the marks. If you have been emailed about eligibility for the SIC test, your mark will be 0 at the moment. We just can't upload like a blank, basically. So you should be able to see that. Has anybody been able to see it yet, or because I don't know when it goes through. So if someone can give me a thumbs up if they've seen it or some indication, then I can. No, it doesn't look like it. Okay, so I'll give you some statistics because I like them. The pass rate for this test was 45%, 44.5%. So 33 of you passed out of 74 who wrote. The highest mark was 82, and the lowest mark was a 26. So there was quite a high, or there is quite a large variance in the testing outcome, if you want to call it that. So I just want to find out from you guys kind of what happened. And I asked the question with the intention of getting feedback from you. It's not only a one-way street. If you had the opportunity to tell me something that I should do differently, now's the time to do it so that I can make those amendments or changes to, for example, not the level at which I'm pitching the question, but like, I don't know, just anything, because I don't know what I don't know, right? And so and then second to that, that will inform me how I can prepare you better for the FISA, the final test, which is worth a whopping 50% of your grade. So I am going to leave the floor and the chat open now. I'm gonna say to one lady here, she informed me, she asked me for the memo for the quiz, which possibly I could have released earlier, which would have better prepared you guys. So that's something I take note of and cognizance of. So that's something I should do better. If I give you like a quiz test or preparation thing, I should provide the memo as soon as possible so that you can prepare better. So that's one thing. The second kind of point was, what was Yeah, that's all that I have in my head right now. It will probably come back to me. So yeah, I don't mind you guys being ruthless, but I can't do anything with nothing. So you have to speak up, or else I'm just going to carry on going like everything is roses, and I know it's not. So what happened? Like, talk to me. Obviously, you don't know your mark, but I know most of you will know that you were all complaining on the group, the WhatsApp group, giving emojis. Not all, most. Questioning style. Okay, so I'm going to read it out for those who can't see it. Ms. Vokwana. The questioning style was vague. I was personally confused about what is required from the questions. Okay, noted. Can you give me an example off the top of your head? Or maybe I can think of, there was a question, the last one, question 4. It was about strategy. I think it was something along the lines of the company is, and I'm being as vague as possible because some people have to write the SIG test. Now that question is not coming up, so it doesn't really matter. But oh, there's a construction company, they're not performing well. What can they do to compete, or something like that? And so that's maybe an example of a vague questioning style. Am I right? Is that accurate?
Good evening, Mr.
Hello.
Adam.
Yeah.
So personally, on my side, I think the questions could have been phrased a bit better, more direct as to what exactly am I expected to apply, in a sense, because it felt like, to a certain extent, I must speak about everything that we've covered, and then again I'm like, no, but you can't cover everything in 10 marks or 8 marks. So I don't want to lie, I was confused throughout the paper. The only answers that I was sure of was the framework. The intention was literally
the 5. Okay, the 5 marks.
Throughout, I was just like, am I expected to focus on chapter 1 or a bit of chapter 1 and chapter 2, or what exactly? So it was just democrat for me.
That's fair. That's fair. And so what I've dropped in the chat is the NQF level 8, which is the postgrad level, the level descriptor. So the paper gets moderated, which means someone else looks at it. And so my moderator said, no, these questions are too easy. You need to pitch it at a higher level. So, in your typical advanced diploma, you could like point to a particular chapter. We would point more out to you, like, oh, use Porter's 5S or 5, Porter's model for strategic development. And then you would know, okay, I got to use Porter and speak about Porter and the 5 different things, buyer, bargaining position of the buyer, supply, whatever the case may be, or speak to the framework. And so my moderator said to me, I teach the diploma as well. So he's like, these are not diploma students. It needs to be often unpredictable context with high level of professional like ethics, or like you're working at a complex problem solving scenario. And so this is the level which you can be expected to operate at. Some of them are vague, yes. and I left it vague on purpose because you could do it under the chapter 2, maybe, you know, some leadership, and maybe I was looking for that cross pollination of, okay, some leadership, some management, some best practice. Let's talk about FISA and now for a minute as well. So you might be faced with a case study where there's some legal issues, there's some best practice issues, and there's some management issues, strategic issues that you need to sort out, and you need to touch on those things to say explicitly to me, here's some management issues. These are the things you need to look at. This is the best practice. These are the things you need to perform as a company. Here are some legal issues that you need to sort out and make sure that the contract is according to XYZ or whatever. Yes, I saw one hand. Busisiwe, you can go ahead, but I think it was Adelaide, something like that. Mr. A.
Yes, it was me. It was me. So, but you can let Busi go ahead first.
Okay, go ahead, Busi. Okay, looks like the floor is yours, Mr. Adelete.
Yes, good evening. I want to agree with Kakamba. I also felt like the questions, when I analyzed them, they wanted a bit of everything that was covered in the chapters, to a point whereby when you skip to another question, it seemed like the same thing that was asked in the previous question is the same thing that they're also looking for in the next question. So yeah, for me, it was a bit complicated because you didn't know what chapter you want us to elaborate on.
Go ahead. I think the next person. Thank you for that. It is noted, Busi. I just want to give Busi before I respond. Okay, Busi, maybe you can chat, or unless your microphone is muted. I'm always waiting for you. And then Potela, I see. Go ahead.
Oh, may I come in?
Yeah, that's perfect. Go ahead.
Yes. Yeah, I think from the comments I had, I think it works both ways. Some people may like the straightforward questions. Some who are experienced in the industry, who knows how things works in the companies and the production lines, they may feel comfortable with the of the question that we asked because they know the terminology and everything. But some may only study what is presented in the lecture, and then not having much of the background knowledge of the industry. I think that's where the disadvantage is to the others. So perhaps the questioning made me start both sides to say, okay, there are people who are not experienced in the industry. It doesn't come out because sometimes you need to cram to say, okay, this slide speak about this, and then you must say 1, 2, 3, 4, 5. If they ask, then I must memorize all the 5 concepts. But some people know it from practice that those concepts applies because they've done it for years and that, yeah. So perhaps striking the balance between the experienced and those maybe who are not in that industry yet, but they're trying to learn about it, maybe to tell concepts, but not them failing because they don't understand the background of the thorough background of the industry. Because we don't spend much time, I think, during lectures to to actually discuss the concepts, make examples, present situations. So it gets difficult maybe sometime when you study, maybe you limited time and everything like that to pick up the concepts before the test. Yeah, but I think at the level, yes, it requires us to to say, okay, I'm going to research more about this and find out how it works. But obviously, if you're not there for a long time or enough time, you end up trying to figure out what this question is asking actually. I think striking the balance between the two maybe it maybe will assist the majority of us. Yeah, thanks.
Okay, thank you for that, Mr. Potela. That is, yeah, it's valuable insight. I agree with you. Maybe we can spend a bit more time in the lectures discussing those, let's call them more straightforward points, because in the test or in answering any of the questions, you would still get awarded marks for noting things like, if we're talking about, let's talk about Porter's, like the Porter's model, you would still get awarded marks because you still needed to define the concept or describe the point marks of 1, 2, 3, 4, 5. You would get more marks, let's say 4, if it's out of 8, you would get 4 marks for the kind of the basic stuff, and then 4 more marks for applying that to a greater context or linking it to an industry relevant example or any example from the textbook or any other material. So yeah, I like your feedback. Thank you for it. Same with all of the other members. I think it is valuable for me to know and understand that, so I can also, yeah, as you say, like pitch it at the right level. Okay, so if there's nothing else, I think we can move to my next point, which is the project deadline. I've had one group email me about a particular person not being participative. I asked them to then send me an email with that person and identify who it was, but nothing as yet has come through. So yeah, I'm only to assume that it's all going well, because it's 2 weeks from now that the deadline is. It's not on the project brief. It said Tuesday the 23rd. It's actually a Thursday the 23rd. So I'm just here to check in again. Is everything progressing fine? Now is the time to kind of, I don't want to say it, but like a cry for help, or like a request for an extension, request for assistance. I know some of you have asked me, but the times given were very, it's difficult for me because I have lectures during the day, and then every other night of the week I'm kind of expected to be home, and so I can't really give up that time to give feedback to my students. And the management is not really being flexible enough to be like, oh, you can have the morning off if you continue to lecture at night. So it doesn't really work like that. So I can obviously help where I can in terms of what's it called, like even on the WhatsApp, like giving voice notes there. If you leave me a voice note, if you like send me some stuff, I'll try to get back to you. Yeah, so let me know how it's going. Okay, so I take it from the silence. There's nothing. Yeah, if there's something you'd like to discuss now or tonight, this is the time for it. Let me just read this question. Okay, the question is, will you be strict on the max number of pages, 15 for the project body? The answer is no, I will not be strict. Yeah, so basically it's quite a comprehensive project, and so yeah, I'm going to be not too. Please don't send me a mini thesis, because that you must write, I think, next year. But yeah, I'm going to be, if it's 20 pages, I'm not going to penalize you, in other words. Or if it's 30 pages, I might kind of get into the area of like, this is too long. But yeah, 20 pages is perfectly fine. It's still within kind of a reasonable amount. Okay. Let's get into it. Okay. So there are two slideshow presentations which I've uploaded. This one is the more recent one. It's the extra slides, which just gives a more shortened, condensed version of the shortened, condensed version of the same content. So this is the extra slides, which is not extra. It's just like a recap or I guess summary version. Then I'm going to start with so that's just so you know, it's on Blackboard. Can you see the original kind of slideshow where it's like the purple and pinky slides?
Yes, we can.
Yes. So another question was, sir, can you please provide a memo for the quiz? I will be doing that. Yes, you will be able to see it now, I think. I think Kelly Lee also asked for that. So I changed the settings, and you should be able to see the quiz memo or the suggested answers now. If not, I will just have to figure it out after the class. Okay, so let's get into the chapter. Chapter 6. So legal issues in contracting. We are in the legal sphere now. I think you can think of yourselves now as putting the lawyer hat on, if you want to call it that. So the objectives for this chapter is to identify elements of a valid contract, how to differentiate between alternative contract strategies and types. There's like key differences in components of business-to-business type contracts for the supply of goods and services, which is different to a personal contract. And then dispute resolution frameworks, like different ways in which you can sort that out. And then there's obviously going to be some kind of an awareness of regulations that govern international trade and the protection of intellectual property. So that's more of a globalization thought there in terms of the laws and stuff. Okay, so I thought I'd put the summary, which is at the end of the slideshow, at the beginning, as well. So that you can see kind of where we're going. So what we're going to cover is something that a good contract has. And these are the kind of all the things. So it stipulates what, where, and when something is to be provided. It identifies the supplier and the purchaser. It defines various roles and relationships, as well as the responsibilities thereof. It sets some standards. It deals with issues of time, payment, and change. So change here is not money change. It's like change processes, like how things will change if things change. Provides some remedies or speaks of breach of contract. So remember, this is what a good contract will do. It will provide a remedy for breaching of the contract. It covers issues of bonds, guarantees, and insurances. And it contains mechanisms for the submission of claims and the resolution of disputes. Okay, and then this presentation has, so like I said, this is at the end, but I will point it forwards. This presentation will discuss factors of commercial contract practice, provide an overview of generic contract provisions and procedures, so how you could possibly set a contract up yourself, given a little generic template. It introduces areas of procurement and acquisition, competition and antitrust legislation, international trade law, IP, which is short for intellectual property, and freedom of information, insolvency, employment rights, and that's on the transfer of an undertaking, TUPE. That's a contracting term. Okay, so as a commercial practitioner, you will become involved with a wide range of legal issues. So that can be with the briefing and liaising with, managing internal and external legal advisors, also with the drafting, negotiating, and administrating of the contract, as well as like licensing agreements, confidentiality agreements. Then you will be, once it starts to hit the ground, ensuring compliance with organizational requirements, and that can be operational as well as legal there, but just in this context, legal, interpreting different legislation and regulatory frameworks, rights and obligations under the contracts, etc., appraising contract frameworks. So looking at the different frameworks and which one is better, which one would you choose, etc. So let's start off with an example here. You're a engineering manager. You've been tasked by the board of directors of your company. Let's give it a technical capacity. So you started out at the company and you know everything about this particular machine and sets of machines. You know the ins and outs. You know that this company makes it and they're the best and this is why it's the best, etc. And this machine can be integrated into like a larger factory setting where it can integrate different pieces and kind of like get you like a keystone type of performance if you integrate the whole thing. So then after a while, you are awarded the right or the opportunity to become or come on board as the let's call it the project manager, because they say, okay, you're going to run with this, you're going to be the head, you're going to be the lead. You're the engineering manager, but you got to think about yourself as the commercial manager. So you know all the technical stuff, and maybe you need help sharpening all the other things, like we were talking about finance, in this case, law, legal type of things, because you're going to expose to this legal advisor of like, okay, signing contracts. Now you're going to draft the contract. What does the contract have? What does it not have? Administrating of this. What does the licensing agreement look like? They put in there something about licensing. Then they're going to put in there things like confidentiality, where you as a client of this Keystone company can't disclose it to other competitors, etc. So they're going to put their machines in your company, and they're going to want you to sign this, but you don't want to fix yourself there. So you got to have that requirement. Then there's organizational legal requirements, where what you can do, what you shouldn't do operational requirements, which you need to tell them. Then there's the laws of, and this company maybe, let's say for example, it's based in the EU in France. So they've got French laws and rights and obligations there, and we have South African rights and laws. How does the French framework compare to the South African typical construction? So because now you must you must get a piece of land on the company site and you must like build it. So now it's also like a project in that way. So you must build the site, you must set up the roof, and then there's like, if there's delays to this building, how does that impact the guys coming in to put in the machines? And if the floor is not at the correct spec, and then the machine doesn't do what it's supposed to, but because the floor is not at the correct, and so that's the contracting thing. So who pays for those? If I think of it earlier, who pays for those delays? Or we spoke about what a good contract has, like time, the payment, the change. You know, what happens when someone breaches that contract? Do you have you thought of those things? So if you think of it like that, this chapter is touching on all of the legal talk, legal jargon, legal aspects of you as an engineering manager in an organization, where you may or may not have to be engaged with the legal side of things. And you need to be au fait, not a lawyer, but you need to be like competent to look at a contract and say, okay, we're missing breach of contract clauses. We're missing, where's the guarantees and insurances? The relationships are not clearly defined. Who's responsible for technical support? Who's responsible for operational support? Who's responsible for machines breaking after 6 months, after 12 months? What is the standard we're going to go against? Is it the South African standard? Is it the French standard? And so I'm drawing a picture, and I'll come back to this example in each kind of theory anchor point. And I hope that will help you here. So this presentation is very definition heavy. And at this point, I'm going to go into the other slideshow presentation, the shorter condensed version. So there's obviously things that you must go in here, and we'll touch on them again. I'll come back to it, but I want to go to the other slideshow for a second, because so I've put the groundwork down. So let's move on to the other slideshow quickly. I've shifted over on after the introduction, which speaks about commercial contracts and what they do. So let's go to this one here, and I'll start. Okay, so can you now see the extra slides? Looks a bit different. It's blue, and it's got a chapter overview. Just give me a thumbs up. Okay, cool. So there's 6 topics or chapters, if you want to call them. This slideshow is only 20 pages long, so it gives a nice summary, and it doesn't bore you guys too much. It keeps us thinking, and yeah. So there's 6 points here. Similar themes: contract formation and key elements. Contract terms, so there's an express and an implied contract terms. Then there's exclusion clauses and UCTA, we'll speak about that. Misrepresentation, mistake, and duress. Topic number 5, or heading 5, is discharge and remedies for breach. Remember, like a good contract will have these things. And then dispute resolution frameworks, or how to deal with these disputes. Okay. So here you need to know and understand what are the legal foundations of a binding commercial agreement. So what are the key elements of contract formation? So there's a clear, unambiguous proposal to contract on specific terms. That's the offer, right? So then there's a unconditional agreement to all the terms of the offer. So here we speak about an acceptance, and then there's a consideration, which is something of value is exchanged by each party, so money, goods, or services. And then intention to create legal relations. This is presumed in commercial contexts, sorry, it must be a genuine intention. So here's an important clause in bold. Without all four elements, no enforceable contract exists in English law. So when they say English law, they're referring to a set of standards within British law. And I think in South Africa, we've based some of our legal system on theirs. So if you go to court, for example, all of these elements need to be in place in order for you to say that, hey, like there was a contract that took place here. There needs to be some kind of offer. It needs to be clear and unambiguous. There needs to be an acceptance of that offer. Some exchange of value needs to take place, and then intentional to create a legal relationship. So some kind of, signature or handshake or some kind of commitment or intention, and it must be genuine, as it says there. So these are the four essential elements of a contract. And when we move to formation issues in commercial practice, so this is the next kind of topic. We speak about the battle of forms. So whose standard terms prevail when both parties submit their own? There are some counter offers. Any exchange of terms kills the original offer and creates a new one. And then letters of intent. So these may or may not be legally binding depending on the wording of the letter. And then invitation to treat versus offer. So tenders or RFPs are invitations, not offers. So there's a legal difference to those two definitions. And then electronic contracting, is the offers and acceptances via email systems have the same legal force. So that's saying if you agree via email, you are still legally bound by that agreement. And then privacy of contract. So only parties to the contract can sue or be sued on it with limited exceptions. Again, there's an exception to every rule. So what is this topic underlining here? So there are always going to be some issues when it comes to the formation of a contract, a legal contract. And these are the issues you need to be aware of so that you can overcome them. And so when we speak about maybe buying a house or buying a car, there's very little there, but there are some legal requirements. So buying a house is a bit more firm or longer. So there's, there must be a offer to purchase. You must put in fill in a form, and there must be specific clauses, and then you sign and initial each page. And so if the offer to purchase this thing, maybe they can come with a counter offer. So they are changing something on the original offer to purchase. So this now becomes a counter offer, and this changes the original offer of the contract, and it supersedes it almost by creating a new one. And you can then counter their counter offer, and off and off we go. So there's a challenge there when it comes to formation of this legal contract. Then there's as I said there, a letter of intent. You may receive a letter of intention to buy this company, but that doesn't mean that they're possibly legally bound by it, depending on the wording is what they say there. So legal teams are very clever in that they might word it like, oh, we want to buy your company. And then they are required to provide certain documentation, but it could also, be a different thing that they're busy with. So this becomes then the battle of the forms. So you just get buried under a whole bunch of paperwork. So I think that's all the points that I wanted to highlight there and make mention of. So when we speak about contract terms, there are two different kind of terms. There's an express and implied contract terms. So here it's about defining the scope of contractual obligations. Okay, so I'm going to bring this back to our original little story about the technical machine. So when you go to this company, this French company, for example, and you say to them, okay, here's kind of my written terms and conditions, and they're recorded, and on a piece of paper, and it's written, and it's very clear. If you make an if they make an oral presentation claiming a certain output of this machine, like, oh, it can make 50,000 units, and the downtime is like 90. The uptime is 98%. So these oral presentations, which are made during negotiations, can be incorporated into the written terms of, and they can be expressed in the contract. If the machine doesn't make this amount, then you guys have to send a team on your bill to come and sort it out and figure out why we are not able to make what you claim the machine can make. And then there's implied terms, which are inserted by statute or courts without explicit agreement. So, like the Sale of Goods Act comes in here, the Supply of Goods and Services Act. So there must be some kind of satisfactory quality or fit for purpose, and that's the statute. That's the law of the land, if you can call it. And then the custom or trade usage. So standard industry practice is assumed by both parties. So if you're in the construction industry, there are a set of norms and practices which is assumed as a standard industry practice by both parties. So that's the trade. And then the last one is the court. This is, again, imposed by the court of the land, and this is to give the contract business efficacy, what both parties must have intended. And so, again, to reiterate, these are implied terms. So they're not necessarily stated explicitly in the contract. But you as the purchaser or, purchaser of this said machinery or equipment, know that you can lean on or use the implied terms of the contract because you're both in the same industry, and there's a standard industry practice that you both parties assume. So those are the express terms versus the implied terms of a contract. Then we speak about things like conditions, warranties, and innominate terms. And that one is something I had to read up on. So if I get that one a bit squiggly, please just read it again. We'll all read it again. Okay, so conditions. These are the core terms going to the root of the contract. Breach entitles the innocent party to terminate and claim damages. It happens very rarely in manufacturing settings, but it does. It has happened. I've heard of it through friends and colleagues. Warranties. These are less important terms, believe it or not. Breach gives a right to damages only. The contract continues. And then innominate terms. This is classification depends on the consequences of the breach. So this is where it's kind of a gray area. So serious consequences are equal to condition-like remedy, whereas minor is equal to more of a warranty-like remedy. So I like to view this as a sliding scale. If you think about how the Basic Conditions of Employment Act kind of goes with severity of the case. So if there's gross negligence, serious consequences, someone dies, then the condition-like remedy is more serious, where it's the person who is suing can terminate the contract as well as claim damages, like, oh, someone died on the site or something like that. And then the more minor issues are it's less important terms. So the breach gives right only to damages. So, okay, your car you can claim for the wheel of your car, not your whole car, because your tires got slashed during like a riot or something like that. So those are the different verbiages within a contract which might come up. Then there's something called exclusion clauses and UCTA of 1997. So these are controlling list risk allocation through contractual limitation. Oh, it's a mouthful. So basically, these are all the limitations, the ring-fenced part of your contract. So if you want to make something be excluded from a contract, like exclude something, it's just what it is, then you can, then this is where that exclusion clause comes in. So this clause attempts to exclude liability for breach. The limitation clauses cap it. It must be incorporated into the contract, so signed, notice, or course of dealing. So basically that interpreted contra pro forentum, it's ambiguous clauses construed against the party relying on them. Ambiguous means, you guys said it, vague clauses. And so the UCTA is Unfair Contract Terms Act of 1977. This controls exclusion clauses in business-to-business contracts. And then there's a bold point there saying negligence, liability for death or personal injury cannot be excluded. So they, it states explicitly what I mentioned previously, where there are some things that cannot be excluded, gross negligence being one of them. Other liability exclusions must satisfy the reasonableness test under the UCTA, and that's section 11. You can go read that up. But it's basically just, you can just say, like, you can think of like, oh, is this reasonable? Are these things reasonable? Did the person, was it a reasonable request by someone to, operate within working hours? Like, yes, of course, that's a reasonable request. Okay, so key factors to reasonableness is bargaining power, inducements offered, knowledge of the clause, and insurance position. Okay, so we are moving to topic number 4. So this is misrepresentation, mistake, and duress. These factors that can void or voidable a contract. So misrepresentation is a false statement of existing fact that induces another party to enter a contract. So basically you lied. Fraudulent misrepresentation, you made knowingly or recklessly damages or rescission. Okay, and then negligent misrepresentation made without reasonable grounds. So you didn't know, but you should have known. And then innocent misrepresentation, the party believed the statement was true. The court discretion on the remedy comes into play here. Rescission is the unwinding of the contract. This is the primary remedy. This restores parties to a pre-contract position. And then bars to rescission, affirmation, lapse of time, third-party rights, and impossibility of restitution. Okay, mistake, economic duress, and undue influence. So a common mistake, both parties share the same fundamental mistake. So for example, the subject matter is destroyed. It's like the machine was destroyed, right? So both parties like share in that mistake. Mutual mistake, parties are at a cross purpose, so may prevent the contract formation entirely. Then unilateral mistake, one party is mistaken. The contract generally stands unless the other party knew. So only one party was mistaken. So economic duress, and this is illegitimate commercial pressure. So example, the contract renegotiation under threat. So you you went into this under economic duress, under a threat. Duress renders a contract voidable. The victim must act promptly to rescind. And then undue influence, relevance, where one party dominates the other. It's less common in commercial. It's more in your legal cases. Okay. Again, like these are the legal terms that you will be expected to know when dealing with contracts. And so that like the definitions are important for you to know as a commercial manager as well. Yeah, just so that, again, to recap, that you are au fait with these things. Discharge and remedies for breach, how contracts end and what happens when they don't perform. Okay, so performance, both parties fully perform their obligations, which is most common. The agreement, mutual consent to bring the contract to an end. Novation, accord and satisfaction. Frustration, these are unforeseen events which makes performance impossible or radically different. So example is force majeure. This, just a note here that says that courts are reluctant to relieve commercial risk here. So in terms of frustration, it is very narrowly applied. So they will only just discharge you under very specific circumstance of like frustration. Breach. This is an actual breach where it's failure to perform, or anticipatory breach, advanced repudiation. So the innocent party must decide whether to accept repudiation and claims damages or affirm and insist on performance. So what does this mean? If the company in France, you're the innocent party, for example, here in South Africa, if they breach the contract and they say, okay, we can't hold our end of the agreement of the contract. So you, as the client, let's put it, or the innocent party, can decide whether to accept their repudiation, so what they pay you back, or in terms of claim damages, what you are claiming from them. Or you can say to them, no, I need you to finish this job and put this machine in. Like, I don't care what you are going through, but this is something we need as a company here in South Africa. Send someone over from France. So you affirm or you insist on the performance. Okay, so here are some remedies for breach of contract. I'll touch on a little bit later in the second half of this lecture, the frameworks for dispute resolution as well, something that you can go through. So we talk about damages. This is the primary remedy. So it aims to put the innocent party in a position of, if the contract had been performed. So there's an expectation loss, which also known as loss of bargain, versus a reliance loss, a wasted expenditure. And then there's a duty to mitigate. So the claimant must take reasonable steps to reduce their loss. Liquidated damages, pre-agreed sum. Usually it's a pre-agreed sum, valid if a genuine pre-estimate of loss. This is not a penalty. Then specific performance, court orders party to perform, rarely granted in commercial contracts. Injunction, this restrains a party from doing something. So breaching a restraint of trade clause, as the example here. And then the quantum meruit, reasonable payment for work done when no price agreed or contract fails. So this comes into effect when you've done the work, but there was no price agreed or the contract has failed. So these are the different remedies for breach of contract. So each of these, so damages or liquidated damages or specific performance, injunction, quantum meruit. Dispute resolution now, onto the last topic for this kind of summary version. So how do you manage and resolve commercial disputes efficiently? And there are 6 points there. So they are set up in a ladder, and you as the commercial manager also need to decide, like, okay, what is the best way? And we'll talk about that just now. But what does it mean? So bullet number 1 speaks about negotiation. This is the fastest, cheapest, and most direct way, because you're talking to them, direct discussion between commercial managers or companies. Mediation, this is where you'll have a neutral third party, which facilitates some kind of settlement. It is non-binding, but is highly effective in that it takes away a lot of time. So it's the second fastest. Adjudication, this is where statutory right in construction, so the Housing Grants Act of 1996, where it's quick, it's binding, it's a binding interim decision. So there's, the CCMA comes in here. They have the right to the Commission for Conciliation, Mediation, and Arbitration, which is coming down further over there. But adjudication is mainly within a specific statutory right. There's an expert determination, which is a binding decision by a technical expert on a specific issue. And then bullet number 5 talks about arbitration, which is a private, and it is binding, and it's governed by the Arbitration Act of 1996. This is increasingly used in international contracts where you don't have 2 companies from the same jurisdiction, legal jurisdiction. So then arbitration comes in where a private third-party company has the binding say on international contracts. Number 6 is the most expensive. It is, however, this is litigation. These are court proceedings. It's public. It's slow. It says they're expensive, and it is binding and enforceable. And lastly, you should seek the resolution which has the lowest effective rung. So meaning which is the easiest to do, least complex, quickest. So maybe it's a bit more expensive, but it'll be quick. So it's most effective, and that's what you need. Or maybe you want to go the long way, but it's arbitration. Maybe it's slower, and more cumbersome, but it's cheaper that way. It might turn out to be for you. So that's a decision that you can make there. So how do you choose? There's got to be some kind of, I guess, rubric or choosing matrix, right? So here are your key considerations, which you will factor into your decision. Number 1, you are looking at speed. So is this adjudication and mediation the fastest? Or it's saying there adjudication and mediation is the fastest, litigation is the slowest. Then number 2, you are looking at the cost. So your negotiation, mediation here, as it says there, are the cheapest, arbitration and litigation most expensive. Confidentiality. So if this is a key consideration for you, you want it kept quiet, then you will think about arbitration and mediation are private, whereas litigation is a very public sitting or showing. Enforceability. Sorry, I skipped one. Expertise. So arbitration allows appointment of a sector specialist arbitrator. That's if you want an expert. Enforceability. How enforceable is this? I'm blanking on the word. This resolution. So here, enforceability, like court judgments and arbitration awards, and enforceable across jurisdictions, so across international laws, basically. Then a key consideration is also relationship preservation. So this is interest-based method, so negotiation and mediation protect the ongoing relationships. So it's pretty much closed door, and they try to do it in a way that the relationship between other companies, people are kept intact. you must always check the contract dispute resolution clauses before commencing proceedings. So there should be, in a good contract, as we said, some type of contract dispute resolution framework or method or process. And so you, as the commercial manager, will have to go and look up at those clauses and say, okay, what do we need to do? What does the original contract say? How do we deal with this topic, or how do we deal with if we come to a crossroads? Okay, some key takeaways. Contracts require an offer, acceptance, consideration, and intention, and all four must be present to be legally binding. There are some terms in a contract which are expressly stated, and often there are also some implied ones. Your job will be to define those obligations. Exclusion clauses are very strictly controlled by statute, by law. Commercial managers must identify and manage vitiating factors, so things like misrepresentation, mistake, duress. Then some breach triggers specific remedies, so understanding how discharge routes limits exposure. Then when you get to that point, if you get to that point, you got to choose the right dispute resolution mechanism, which is right for you at the time. So if it's negotiation, mediation, adjudication, arbitration, or litigation, whichever one saves you time and cost. The last statement here is legal literacy is a core competency for commercial managers in project orientated organizations. And so this is something that you are kind of not going to get away from. Even if you want to buy a car or a house, which most of you already maybe have done, you need to know and understand what it is that you're signing yourself into for your own good, because maybe they will put something in there that you don't really like and didn't think you are agreeing to. So it's very interesting. You need to be very meticulous about reading all of the things. And so, yeah, that's where I'm going to pause it or end it, this first part for now. I just think I need about a 10-minute comfort break, and I think you guys do too. So what I'm going to do now is stop the recording, and I will pick back up when we come back in like the second half, where I'll take you through the second slideshow. Just I'll take some key important slides there, so not everything. So let's meet back at 7:20 to finish off this round of slideshows. Okay, let's go ahead. If you guys hear some background noise, I do apologize. Okay, so let me get to the correct starting point. Okay, so share my screen. Okay, it appears I have not clicked stop recording, so I will just continue recording. And yeah, I'll try and split the videos into two because there's no need to have about 15 minutes of nothing happening. Okay, so I shift over now to the kind of conclusion of the theory part. We still have another couple of sessions whereby we'll get into some more practical insights around the previous two chapters, maybe some breakout rooms again, interacting, engaging with the material on a different level, maybe starting a discussion point and then having you guys talk through it, talk down in a larger forum will also be helpful. So maybe that's something we can look forward to for next week. But I'm now at the slide number 12 of the PowerPoint presentation, which is on Blackboard. And this speaks to contractual issues. So it states here, a prudent commercial manager will need a thorough understanding of the following items. So there's a couple of bullets, and under them there are some sub-bullets. So the procurement process, so the post-tender or bid negotiation stage, the assumptions made by the purchaser and the supplier, the parties, and this is all parties' expectations of the service relationship. You will need a thorough understanding of contract terms and conditions. For example, now these are the main ones under the contract. So purchasers' duties and responsibilities, suppliers' obligations, main cost determinants, certification and payment mechanisms, purchasers and suppliers' rights if things go wrong, to name but a few. And then the last larger bullet here is legal implications of the contract for which they are responsible. So that's an important slide to just know, like, all of the things that you need to have an understanding of and what's expected of you in terms of the entire contractual issue. And then I'm going to go down to slide number 15. So I'm going to jump around a bit so you can go into detail. But for now, I just want to delve into slide number 15, which is also important here. It states 10 common contract behavioral patterns and norms. So this is kind of a template which you can work off when you don't have an idea of, okay, where do I start as a contract? So if you go through these 10 points and you answer all of them, you have the beginnings of a very good, solid contract. So role integrity, so requiring consistency, involving internal conflicts, and being inherently complex. So the behavioral pattern of reciprocity. So this is the principle where you receive something in return for something given. So you give as well as you get. Implementation of planning. So you should be able to have some kind of planning and implement a planning mechanism. The effectuation of consent. So some of the norms are flexibility. You will need to be flexible. Contractual solidarity. The restitution, reliance, and expectation interests. So it says there the linking norms. It's probably referring to something within one of the reference material. The creation and restraint of power, the power norm. So the bullet number 9 is proprietary propriety of means. So this is the mechanism through which relationships are maintained. And this may include formal or informal processes and customary behavior. So then there's also something around the norms, which is like harmonization of social matrix. And go look at harmonizing, basically. Power norm is considered to have the most influence. Okay, I'm not going to go through the definitions. You would, of course, need to know these so that you can make a case for what is a contract. Then another important slide I'm going to jump to is we've covered this in terms of like what contracts are, what do they do, standard norms, etc. And then we touched on the English common law in the other contract. I didn't mention the religious laws such as Sharia as an example, but you would need to know these things as well. Slide number 20. Yeah. So here it goes into much detail about contract strategy and type. So the provisions of a contract should define the responsibilities of the parties, etc. Allocate risk, determine effective payment, and then the next slide is this one. So your contract choice has a impact on the project success. So there's different choices and templates and frameworks. And so the choice depends on the context. And so your contract type has a considerable impact on the project success is what it says there. And you should obviously aim to give the maximum likelihood of attaining the objectives of the project. So there's a risk allocation little image here via contracts, stating things, I guess visually, the different types of contracts that you have based on supplier responsibility and buyer responsibility. So when the buyer responsibility goes up, then the cost reimbursive or fee-based contract structure is best. Versus the axes here on the other side where it's supplier responsibility, then the fixed price, which has a unit rate or a lump sum, is best for the supplier. And as it goes up and down the scale, the level of uncertainty will vary. So that's kind of where you want to be at. In the middle section, you have incentive contracts, so guaranteed maximum liability, pure incentive contracts, and guaranteed maximum price. It's just to give you some kind of guide as to where you'd aim to be. And then this kind of puts it also on the selection of contract types, where if the complexity is high, you would kind of go into this, and the uncertainty of the product is high, then cost plus, design and build alliances. If it was the uncertainty of the process is low and the complexity is low, the situation was not researched. So that's just something, a little matrix to help you decide there. Of course, the choice of contract is context. Governance structure has an impact there. But the slide I really want to get to is further down in number 47. So I'm going to jump ahead quite a bit. Pair 47. And we speak about, again, remedies for breach of contract. So contracts need to incorporate provisions to manage the consequences of default by either party. So here you have performance indicators, liquidation, damages, and termination. Right. So these are the remedies for breach of contract. as we stated in the previous slides as well. So bonds and guarantees and insurances, then there's claims, and it can be from both sides, supplier claims as well as purchaser claims. And then they state which type of typical construction claims relate to the use of non-specified materials, defective work, or damage to property, late completion of the supplier, etc. Okay, dispute resolution. Problems can arise. Problems will arise when implementing contracts, regardless of the relationship between the parties or the type of project. A major role of the project manager and the commercial manager is to predict these potential difficulties and implement some kind of intervening framework. So the conflict management or dispute resolution taxonomy. So there's conflict management side, which is non-binding. Then there's the dispute resolution side, which has some non-binding aspects, but also binding. And if you look at the right, it's all of the binding things that we spoke about there: adjudication, arbitration, expert determination, litigation, negotiation. Whereas we spoke about that for dispute resolution, not necessarily conflict management. So you will be on the side of possibly conflict management, where there's dispute review advisors, dispute review boards, negotiation, quality matters, total quality management, or procurement systems, where there's conflict and it never gets to the dispute side of things. But you'll constantly straddle those lines and need to know where you will fit and what pushes the thing over. So that's just a nice determination for you to know, okay, where and what is considered a conflict management situation, and is it non-binding, is it binding, and dispute resolution aspects, where what is binding and what is non-binding. Okay, so as these are the aspects. As a commercial manager, you'll need flexibility. Then I'm going to go down to 63, which is IP, or intellectual property. Any innovative or original work that can be traded. IP serves three key purposes: incentivize knowledge creation, accrue knowledge in culture, and then protect a distinctive identity. This is becoming more and more difficult in the age of generative AI in terms of videos, content, video content, written content, and so image generation, it just becomes very difficult to determine. Still easy enough, but it's going to get harder and harder. So it's just something here that you need to be aware of when it comes to legal terms around intellectual property. Who owns what when you're making the trade agreement from one French company to a South African one? And it goes into specific detail there in terms of like commercial contracts often include a pre-existing, so IPR, foreground, which is emerging IPR, and then negotiation of IP terms is a key feature of commercial role during the deal negotiation phase. And 66, insolvency. So what happens when a company becomes insolvent, right? So held to the inability of a company or individual to honor debts that become payable, and or where liabilities are greater than the value of assets held. So in the UK, insolvency is administered via a complex legal framework. And in South Africa, it would probably be the same, where you go through business rescue, etc. And they have a department there, business innovation and skills, and it's an agency, etc. It's just something that you need to be aware of if you're making negotiations with people. Like, what is the clause around insolvency? How are we going to deal if one of the companies goes bust or claims to go bust? Who's protected? How are we protected? How are we going to be dealing with this if that happens? Do we go to lawyers? Do we go to insurance? Because these things can happen, and they're a reality of doing business in the world today. And then, of course, these are procedures. Or possibly you are even the company that goes insolvent. What do you do? What is the steps? And so this is a very in-depth analysis of that. Like, what could you do? What is the next steps? Yeah. This is the transfer of knowledge undertaking, so it goes through there. But then we get to the end of the theory part for today. And I'm going to end it here, and we'll pick up next week. We don't have much time, but we also don't have much content left. So next week we'll get into a really practical session. We'll talk about the final touches on the finance side, but as well as I'll present a little case study on the legal aspects, or mixture of the both, so you can get a practice round of answering questions like that. And then for today, just to summarize again, we covered what a good contract is or has. And then, of course, also we touched on things of factors which influence commercial contract practice. We discussed some regulations, legislation. We touched briefly on intellectual property and insolvency. And so we also had a discussion around some definitions around legal frames and legal frameworks, clauses, warranties, breach, and things of that nature, which all make up our understanding of the legal issues in contract formation or contracting. So yeah, that's all for tonight. A lot of information. I want you guys to go and digest that. Also, I'll be able to give a clear indication as to the test for the SIG test next week. Next week, Monday, is graduation for some of our engineering managers and industrial engineers. So I'll be attending that. It's very exciting. I see some of you on the group are graduating, so I will see you across the stage. Yeah, that's all from my side. Thank you, guys. I'm going to stop the recording now.